Hi, my name is Jacob Sapochnik and I'm an immigration attorney based in San Diego, California. In this video, I wanted to break down the steps of what it takes to legalize an illegal spouse. We have a lot of clients who are calling us, emailing us, that are currently married or intending to marry an immigrant that crossed the border illegally, whether it was recently or years back. And now they're wondering whether the marriage to that illegal person can allow them to get legal rights in the United States. Now, this is a process that is very complicated and will depend on many factors, whether the immigrant came here recently or whether they came here many years ago, whether they came here as a minor or came here as an adult person, whether they crossed the border illegally, whether they were smuggled in here. A lot of questions, a lot of concerns that we have when we interview those clients. But essentially, if a person entered the United States illegally after 2001, April 2001, when it was the last time where they were able to do something to legalize themselves, and there was not a petition ever filed for that person since they came illegally, the process to legalize a person that is currently married to a U.S. citizen who entered illegally has a few steps. And I'm going to try to outline those steps on the board. The first step, of course, is to get married. Once the U.S. citizen is married to the foreign national that is currently illegal, an I-130 application has to be filed. I-130, a marriage petition. So, I-130. Now, the I-130 petition is based on the marriage to a U.S. citizen. The petition is identifying the relationship, put all the information, biographic information as to where the person is currently residing, where is the U.S. citizen currently working. That petition will be pending roughly 4 to 5 months with the USCIS. Now, the I-130 is filed with the U.S. Immigration Service in the United States. It's a USCIS filing, which takes about 4 months to process. Once this petition is approved, the U.S. Immigration Service will forward that petition to the National Visa Center. The National Visa Center is a buffer agency between the U.S. Immigration and the U.S. Embassy. So this is the NVC. That's another, I would say, 3 to 4 months process. Now, the National Visa Center is designed to accept the information from the U.S. citizen. At that point, they will ask for financial information like tax returns, affidavit of support, any other original documents like birth certificates, and they're going to be preparing the case for an interview at the U.S. Embassy. At that point, there's more fees to be paid to the National Visa Center. The I-130 itself is about $420 at this point. There's more fees to pay the National Visa Center stage, another $480. Once the National Visa Center has completed its processing, the case can be forwarded to the U.S. Embassy in Ciudad Juarez if you are Mexican, or any other embassy in the world where the foreign national is from. So this is the last step, is the U.S. Embassy. Now, once the case moves through the U.S. Embassy, it's going to take probably another 3 to 4 months before an interview date can be set. I would say another 4 months. So this is basically where the foreign national who is currently in the U.S. illegally will have to decide whether they're going to leave the U.S. and face the U.S. Embassy in their home country for an interview. So what's going to happen is that once the person decides to leave, the risk is that they're going to be barred for at least 10 years because they spend more than a year illegal in the U.S. in most of these cases. And what's going to happen is that once they get to the U.S. Embassy and they face their interview, in most of these cases, they get denied. Denied. And the reason they get denied is because they overstayed their visa and they left the U.S. At that point, the bar has been triggered. Now, once they denied, they have an option to file for a waiver. A waiver, and typically it's called a 601 waiver. And so what that waiver does, it allows to show if there's extreme hardship to the U.S. citizen spouse, and we can demonstrate the hardship, legally speaking, through putting together a package. The U.S. national is able to demonstrate the hardship they're suffering. If the case is approved, the 601 waiver is approved, the foreign national will be sent back to the U.S. Embassy to collect their visa, and then they'll be able to come back to the U.S. with their visa and get the green card. So this whole process, in most countries, once you leave and go back to the embassy, may take more than a year, even 2 years, depending on where you're from. The only place right now where it's pretty fast is Mexico, where those waivers can be adjudicated in a question of a month or so after their appointment. The bottom line is that this is the only way that currently, we're now in 2011, the end of 2011, beginning of 2012, this is the only way a person who came here illegally can legalize themselves. Now, we're hoping that the law will change. We're hoping there's going to be some more new legislation coming up. But as of today, this is the only way, the only steps. First, filing the I-130, then the case goes to the National Visa Center, and then to the U.S. Embassy, and then the decision to leave the country has to be made. It is very important to make sure the forms and the application are done correctly at every single step of the process, and especially at this point where the case has to go through a waiver process. It is important to consult an experienced attorney who knows how to handle waivers. The bottom line is that it is doable. It is possible to legalize yourself, even if you're illegal right now, came to the U.S. illegally, married to a U.S. citizen spouse. Before you do anything, consult with an attorney and make sure that they know how the waiver process works. If you have any other questions, feel free to visit our website or our Facebook page for more updates. Thank you, and I hope you enjoyed this video.